Welcome, Facebook viewers. My name is Brad Bodis, and you've joined us for this week's episode of the Bond and Bodis Law Office's Facebook Live. We're here to talk about an important issue this week. We're going to talk about the end of the eviction moratorium in Alabama. And we're very fortunate to have my friend, Holly Ray, who does a great job with Alabama Legal Services. She is the managing attorney of the Huntsville, Alabama office. Holly, thanks for joining us today.
Thanks for having me.
So for our viewers, Holly has kind of become a friend of the Bond and Bodis Law Offices. She joined us on an earlier Facebook Live where we talked at that point about the rules pertaining to the eviction moratorium when it was in place, and talked generally about the eviction process in Alabama. And then subsequent to that, Holly, you did a appearance on our podcast, my partner, Ron Sixtus. To our viewers, if you haven't seen it or haven't listened to it, I should say, the name of the podcast is Next Lawyer Up. It's hosted by my partner, Ron Sixtus. He does a great job. He interviews attorneys from throughout Alabama, throughout the country, has had some great guests, and one of the best was Holly Ray, who's joining us today. It was episode 110 of Next Lawyer Up. You can find Next Lawyer Up on any of the popular podcasting services, or you can go to our website and click the podcast link. But Holly appeared on episode 110. Holly has a fascinating background. Holly, you're a Huntsville native. Family on both sides goes back at least a couple of generations in Huntsville. I think it was your grandfather that worked with the NASA program?
I did. My maternal grandfather moved to Huntsville to work on the Apollo program. He was a copper worker. Okay, great.
And now I learned something important. First, an interesting factor, and we talked about this on Holly's first appearance. What I just think is so cool is she skipped high school. She went straight from 8th grade to college, which not many people can say, but it tells you a little bit about how smart my guest is today. I try to have smart people to offset me. But the other important thing I learned is I shouldn't address you as Holly. Apparently, everybody close to you just refers to you as Holly Ray. Your first and last name go together.
Yeah, I guess it's one of those Southern phonetic pronunciation things, but my whole life I've been Holly Ray.
I've learned Holly Ray, so I'm going to try to use your proper name today. So, folks, when Holly joined us last, we were in the midst of the moratorium that existed on evictions, not only in the state of Alabama, but nationwide at that point. It was a moratorium that it put in place by an order of the CDC. Well, Holly, on August 26th of this year, the United States Supreme Court stepped in and issued a ruling stating that essentially that moratorium that had been put in place by the CDC was unconstitutional. So the moratorium we had in place for a long time to protect renters, protect consumers during this pandemic went away rather quickly. So I want to talk in some detail today about what happens next. I know your office has been overwhelmed in working with people facing eviction. I want to talk about the process in Alabama. Why don't you start, if you would, by just giving us a little bit of background on what you've seen while the moratorium has been in place and now what has happened since that moratorium has been lifted.
Sure. So the moratorium through the CDC was in place for about a year. It had a few predecessor moratoriums ahead of it. One of them was the CARES Act, which came out at the very beginning of the COVID crisis. At one point, Governor Ivey issued a statewide moratorium on eviction in Alabama that lasted about a month. Right. I mention those only because there's still some kind of public perception that they're out there. Both of those have now expired. Right. The CDC moratorium was the law of the land for a couple weeks shy of a year. It came in September of 2020. A lot of folks kind of acted like it was a castle wall. There was, again, a public perception that people couldn't be evicted while that moratorium was in place, and that was actually not true. No. if you qualified for the CDC moratorium, and it had some pretty narrow guidelines on who would actually qualify, it could protect you through the end of the moratorium. When that stay was lifted with the Supreme Court order about a week and a half ago, that is no longer true. But we still saw evictions filed in most counties in Alabama. A handful of counties' presiding judges said, no, we, as basically part of caseload management, are not going to try evictions right now while the moratorium is in place. But in most counties, we saw evictions moving forward. We've certainly, although they could have preceded all of this time, we have certainly seen an uptick in evictions over the past, give or take 2 weeks, when it became clear that the moratorium was going to end and then did end. We've certainly seen an uptick around the state in applications for assistance with eviction defense coming through legal services. Cases that had been held back. What happened is if you went to court and a judge found that you were moratorium eligible, the case wasn't actually dismissed procedurally in most counties. They just put it on what they call the administrative docket, basically set it to the side. Those are now coming back up for hearing now that the moratorium has ended as well.
All right. So I want to kind of give a big picture here for our viewers. The bond and bonus law offices are located throughout Alabama and Mississippi. We help people with money problems. We want people to be aware at this point that we're offering absolutely free initial consultations. And for your protection, for your safety, we'll do them by phone, we'll do them by video, however you're comfortable right now. But we want to make sure you get as much information about relief available as possible. Be proactive. Holly Ray is with Legal Services of Alabama, which also has offices across Alabama. Correct me if I'm wrong, Holly. Holly is the managing attorney in the Huntsville, Alabama office. And Legal Services of Alabama provides assistance to consumers, to individuals, for today's purposes, for renters facing eviction. Holly Ray, I'm sorry, is going to speak today about the eviction procedure in Alabama. I want to let our viewers know that next week we're going to have another special guest, one of my law partners, Ed Woods, who manages our offices in Mississippi and who is also a justice court judge in Mississippi, to talk about the eviction process in Mississippi, because the process is different state by state. So it's important for our viewers in both states to know the process. So with that lead in, Holly Ray, talk about who legal services can provide assistance to and what type of assistance you can offer.
Sure. So we are a provider of civil legal aid. We are, when people say call legal aid, Legal Services Alabama is what they're talking about in the state of Alabama. We are free lawyers for people who financially qualify. For most of our services, that means living at or below 200% of the poverty level. Thanks to a generous grant from the Alabama Department of Economic and Community Affairs, we've actually added about a dozen attorneys statewide. We've added 2 here in Huntsville, who right now are doing nothing but homelessness prevention work, doing eviction defense, we're starting to look at foreclosure defense now with that moratorium lifting. But that is all they do day in and day out. It's taken that level of staff, which, is pretty substantial for a law firm that normally has about 50, 55 attorneys.
Let me interrupt you just for a second. So for 200% of poverty level, what does that mean in real numbers for our viewers?
I'm going to pull it up because admittedly I have a computer that tells me that on a day-to-day basis. It is hard to remember because it's set by Congress every year. For a family of 4, that's right at $53,000 a year. For a single person, it's $25,760. For a household of 2, it's a hair under $35,000.
So it's important for our viewers to know you don't need to be completely destitute. Legal services can provide assistance to a wide range of people, and you have. I know you're overwhelmed, but you do have additional attorneys available now to help people. You can go on with what exactly type of work you do, but I wanted to make sure people understood those dollar amounts.
Absolutely. We do exclusively civil litigation. We are federally funded predominantly, so we can't touch it. And with that comes some handcuffs. We can't touch anything criminal. We can't take any kind of what we call a fee generating case. So that's where you would sue someone for money. Maybe you've been injured or something like that. We don't take those. Pretty much everything we specialize in is what I lovingly call stuff lawyers can't make money off of. Defending tenants from wrongful eviction, defending folks from slumlords, defending folks from predatory lending, folks who have been wrongfully denied public benefits, dealing with wrongful denials of unemployment, wrongful denials of Medicaid. Those are hard things to make money off of as a private practitioner, but they are direly needed services for people in poverty. And that is kind of our niche practice and what we specialize in.
Well, and you do great work. And again, I want to clarify when Holly Ray says that y'all do civil type representation, what that means. Civil is when there's litigation or legal proceedings between individuals or an individual in a business, as opposed to criminal is when you're charged with some sort of crime. Alabama Legal Services does not get involved in criminal type proceedings, if I understand you. And then to further kind of distinguish our two practices, we do represent a lot of the same people. We both are on the side of consumers that are facing financial challenges. Of course, Holly Ray talked about the financial amounts that you must be below in order to get assistance from legal services. And then there are certain types of work. For instance, I think I learned, Holly Ray, if you would talk about this, that in bankruptcy court, y'all do a lot of Chapter 7 bankruptcy work, but perhaps not as much Chapter 13 bankruptcy work. Is that correct?
That is correct. We do a handful of Chapter 7s for folks who either have a wage garnishment that we can't stop any other way, folks who might be facing loss of their driver's license that they need for their employment. In some cases, we can do a bankruptcy for those. In rare occasions, we do it to protect some other benefit that we couldn't protect any other way. But we are certainly not a high volume bankruptcy firm. We are not specialists. There are about 7 of us in the state that know how to do them. What we have found is that obviously 13s and 7s are very different in many ways. For clients who qualify financially for legal services and would need a Chapter 13 to do something like save their home if they're facing a foreclosure, it is nearly impossible for those two Venn diagram circles to meet, of qualifying for legal aid yet being able to fund a 13. For the, I would say, less than 5 clients a year in my 7 counties that qualify, I send them out to private counsel. And in some cases, we pay private counsel to represent them because we just can't be specialists at everything.
And I want our viewers to know Chapter 7 is usually described as a straight bankruptcy. It's a proceeding, it's a quick proceeding where you're able to discharge many of your debts and preserve your assets, as long as you don't have significant assets. Chapter 13 is more of a reorganization type bankruptcy, where you formulate a plan perhaps to catch up on mortgage payments or catch up on rent payments. There are a lot of different instances that we've discussed in other Facebook Live episodes between Chapter 7 and Chapter 13. All right, now having set those kind of parameters, Holly, let's talk about the eviction process in Alabama. So I'm a consumer. I've had a hard time finding work during this COVID pandemic, and I've gotten behind on my rent, and I've been able to put off eviction. But now my landlord's moving forward with the eviction procedure. What can I expect to happen at the outset?
Sure. So the first step in the eviction process in Alabama, no matter what you're being evicted for, is a notice from your landlord. It's got to be a written notice. Right now, it can't be an email. It can't be a text message. It can't be a phone call. It has to be a letter that gives you, in most cases, a right to cure within 7 business days. So if, for example, the most common reason we get these is non-payment of rent, your landlord has to give you a notice that says, here is how much rent it's going to take to bring you current, and it has to allow you 7 calendar days to bring it current. In just about every case, there are other, landlord-tenant issues where you can cure a default. Maybe you've brought in an illegal guest. You had a family member that was evicted, and you've moved them in with you. Maybe you've gotten an illegal pet during the moratorium that you weren't supposed to have. The notice also has to give you 7 calendar days to cure those deficiencies, to find a new home for Fluffy, to kick out your new roommate, whatever the case is. Alabama does have a handful of incurable offenses, things you just can't fix. And generally, they're exactly what they think you are. Don't cook meth in the bathtub. Don't get a pet alligator. Those are both actual things that have happened. Things that you would think would be incurable. The funniest one I've gotten for the record was someone that was collecting gas in milk jugs during that slight moment that we had the gas shortage and the gas prices spiked. This person lived in a high rise and was collecting gas in gallon jugs. Thankfully, not our client, story that kind of came across the listservs. But in general, when we're looking at non-payment of rent, you've got 7 calendar days to bring it current. If you don't, the next step is that your landlord will file an eviction lawsuit against you called an unlawful detainer. You'll be served with those papers, and the method of service is somewhat novel. Most of the time you think, if I'm being served with papers, someone's going to hand them to me, a process server, a sheriff's deputy. That is not true in evictions. In Alabama, if your landlord is seeking just possession to get the property back, to get you out, they can nail and mail. They can stick a copy on your front door, put a copy in the regular U.S. mail, and that is sufficient. These have the shortest deadline in just about any form of civil law in Alabama and most criminal law. You've got 7 days to file an answer, and that is 7 calendar days to file a response with the court. There is no cost to file an answer. It is a checkbox fill in the blank form. You go up to the clerk's office and fill it out. But so many people lose their case at that point because they don't realize that they have to file something to get their day in court.
I want to just emphasize that issue. People don't realize, we talk to folks all the time, Holly. They'll have been served a complaint. It may be for eviction, it may be for a collection matter, and they think that perhaps they could just call the number that's on the piece of paper and say, I don't really owe this, or I contest this, or they think they can write the attorney that's suing them. That's not right, folks. You have to go to the court or mail something to the court, but you need to make sure it's filed in with the court, or you're not going to get your day in court.
Yeah. And for eviction answers, I am never, ever, ever going to tell you to mail it because that 7 calendar days is so fast.
Right.
And I know that, folks, and I'm guilty of it too, but we all, when we have an issue, you Google it, you look it up online. And we get clients who will find law from Oregon where you have to pay to file an answer. That is not true in Alabama. It is free. It is a checkbox form. Every clerk in the state has it. Please go file an answer. The mere act of filing an answer buys you at least another month to find out what your plan B is.
And the reason that is, again, if you don't file the answer, it's a signal to the court that just you don't want to defend yourself, and a judgment will be entered against you by what's called default. But as Holly Ray just said, if you file a response, and this is the same in an eviction lawsuit and a collection lawsuit, there's going to be a court date set. Nothing's going to happen until after that court date. And you say it's about another month in Alabama, technically?
It depends on which county you're in. Under the rules of civil procedure, once you file your answer, that court date has to be at least 14 days out. Depending on how the docket goes, and it's very dependent by judge and by county on how often they have these dockets, how many cases they cap at. Because of COVID, we can't have packed courtrooms right now. I tell folks to expect 2 to 3 weeks. It's a bonus if it takes a little bit longer, but 2 to 3 weeks seems to be the rough average. If you go to court on one of these in the state of Alabama, chances are very good that your landlord is going to be there with an attorney. Most landlords are corporations or LLCs. They're going to need an attorney to represent them in district court. You are welcome to call legal services for assistance with these. Part of why we've brought on new attorneys is to come as close as we humanly can to giving everybody in the state the option of having a lawyer to represent them if there is any conceivable defense to their eviction. But when you go to court, the judge will ask questions about that notice that you received, making sure that the I's are dotted and T's are crossed. If a landlord bonks that notice, then they can lose just for a technicality, for a paperwork error. They're also looking to see if any other kind of, defense might be possible. Maybe the person that's suing you doesn't legally own the property. You would be shocked how many times that happens. We get that at least once or twice a month here in my office, and I know we see it around the state as well. If the judge rules against you, if the judge found that you owe the rent, that you didn't pay it, that your landlord has done all of the proper legal procedure leading up to an eviction, even if you lose, you still have a week to get out of the property. That's because the time to appeal an eviction in Alabama is 7 calendar days. After 7 calendar days, if you haven't either appealed or left, the judge can grant a writ of possession. that I tell people to think of it almost like a warrant, although it's not. That is what authorizes the sheriff to come out and keep the peace while a moving crew takes you and your belongings out of the house.
So I want, again, folks to know the bankruptcy process can have an interplay here in that if a bankruptcy is filed before that actual judgment is entered by the court, the judgment of eviction, the bankruptcy automatic stay will provide an additional period of time before which the actual eviction will go forward. Usually, typically another month or two. And in some instances, you can file a plan to catch up what you're behind on your rent and stay there even longer. But the important date for bankruptcy purposes is acting and filing for bankruptcy protection before that actual judgment of eviction. So to summarize, Holly Ray, make sure I'm right on this. I think I understand the process well in Alabama, but if you are in default on your lease for some reason, typically it's because you're behind on your rent, and that's what we're going to see a lot of, I'm sure, in the upcoming months, that there are other reasons you could be in default, and you gave some good examples. The landlord first has to send you a notice of default and give you a brief period of time in which to cure that default. If you don't do so, then this eviction lawsuit is filed against you. Now, are these typically filed in district court in Alabama or in circuit court?
They originate in district court.
Okay. So district court for our viewers is a court of lower jurisdiction. Dollar amounts, usually, are they below $15,000 now, Holly Ray? Or
20 now. Okay,
$20,000. So smaller dollar amounts. No juries usually involved, or no juries ever involved in district court. And you only have 7 days after you're served to act. And service doesn't need to be in your hands. If you suspect that your landlord is moving forward with an eviction, be conscious of the fact that something may be posted on your door, mailed to you, whatever it may be. Be conscious of it. And you only have 7 days to act. If you don't, then a judgment by default will be entered against you, which is going to shut off most of your bankruptcy remedies and most of what legal services is going to be able to help you with at that point. But if you file a response within that 7 days, and that means go to the clerk of court's office and get something stamped in saying, I want a trial. I don't think I owe everything. I don't think what the landlord's saying is correct. Then you're going to buy at least another 2-3 weeks, probably a month, before a hearing is set. Now, Holly Ray, if I am behind, I've gotten to that point, I show up at the court hearing, what should I expect to happen at that hearing? For instance, what if only my landlord's attorney is there and not my landlord? What options do I have if I'm at that point and I don't have an attorney with me?
So if your landlord's attorney shows up but not your landlord, they don't have a witness that can testify. And so in many cases, you should expect that the case is going to get continued or that they're going to keep you out while they try to call somebody and get them there. One of the good and bad things that has come of COVID is Zoom court appearances. And you'd be shocked how many times we get somebody on Zoom on their, cell phone in their car, counting as a court appearance when they forget that they're supposed to be there. That wouldn't have happened 2 years ago, but that does happen now. Otherwise, the judge is going to ask some questions about, well, did you pay the rent? Why not? An important thing to know in Alabama, unlike in some other states, you cannot withhold rent for repair issues. So if your landlord has failed to do some repair to the property, maybe your air conditioning is out, maybe your plumbing is acting up, maybe you had a sky-high utility bill. There are other remedies for those things, but not paying your rent will still get you evicted in spite of those problems.
I want our viewers, something Holly Ray just spoke to there about the landlord perhaps not appearing in court with the attorney. This is such an important matter. If you find yourself in court for whatever reason, maybe it's a collection lawsuit, maybe somebody's saying you didn't pay a bill. If you've answered that complaint, you asked for your hearing in court, what happens far too often, what I see, Holly Ray, is the judge will advise people to talk, and the consumer will kind of back down, and they'll agree to some sort of judgment, or they'll agree to some sort of settlement. But if they stand up and demand that the court see evidence of their default, often they'll prevail, at least in that initial setting in court. So you do have options, folks.
Yeah.
All right. So if I qualify and I contact legal services, and legal services makes an appearance on my behalf, what options might be available to me with respect to that eviction proceeding?
Sure. So in a lot of cases right now, there are literally millions of dollars sitting on the table in the state of Alabama, and certainly in Mississippi too, in every state,
Sure.
In federal COVID relief funds, emergency rental assistance. So in some cases, us standing there and just being able to show the status of your emergency rental assistance application can be enough to get the case postponed, to get you time to get money in your landlord's hands and let you stay. In some cases, having somebody standing there that's been doing this for a long time, who knows the ins and outs of it, can mean that we find a goof somewhere in their papers. Again, maybe they aren't the legal owner. Maybe they have filed incorrectly in some way, lacked in their notice. It's shocking, but you win about half of evictions based off what I call stupid lawyer tricks.
Right.
Not fun to win off stupid lawyer tricks, but it happens. When none of those things are an option, sometimes what we can do is simply help you negotiate a graceful exit. Sometimes, again, the landlord's attorney, just knowing that someone standing there knows how to appeal these, knows how to file a bankruptcy, knows every trick in the book to get you as much time as possible, gets them to say, fine, I don't want to fight you. Give the tenant 30 days to vacate. Sometimes that's how these end. Obviously we always want to end at trial, but sometimes that's just not possible.
Right.
Sometimes negotiating a graceful exit, maybe getting the money damages dismissed, is the best possible outcome. So you walk away without owing your landlord money. We've also kind of, again, new in the COVID era, we've been negotiating for seals on evictions. Alabama does allow judges to mark a case as confidential, which pulls the proverbial eviction off your record. Pre-2020, I think I'd gotten 2 of those, both in cases of mistaken identity, like they filed against the John Doe, 2 John Does in an apartment complex.
Mm-hmm.
Post-2020, people who had never faced eviction before due to COVID, who life happened and it was very clear that their reason for eviction was COVID-based. We've been able to get a lot of those cases sealed, which opens you up to, I call it the Scarlet E. If you've got a recent eviction on your record, it's very difficult to find a decent place to live. Being able to give folks some relief on that has made all the difference in finding them stable housing moving forward.
Well, that's something I did not know. I'm fascinated by that, because that would provide tremendous assistance to a lot of consumers. And a point you just made is so true. We are finding folks today that never would have been in a bad financial situation in the past, that are just behind on rent, behind on mortgage payments, people we never would have seen in either of our offices in the past that need this type of assistance. So explain that, Holly Ray. So a seal is put on that court proceeding, and a future landlord or potential landlord might not know about this eviction?
Yes. So much like how criminal cases can be sealed, obviously all juvenile cases, for example, are marked as confidential in the system. They're not publicly available. Evictions can be sealed. The example I give to most clients is, you can't go pull the papers from Governor Bentley's divorce, our former love gov. We're not supposed to know who got the beach house. That case was marked as confidential because it served no public interest for the Alabama public to know who got the beach house and the Alabama season tickets. The same thing is true with these COVID evictions. There's folks who never, ever, ever thought they would face eviction. And most of my clients who have dealt with this were hairdressers. The state of Alabama cut their business off at the feet for months and months through no fault of their own. Imagine if the state told you couldn't work for months and months. And by necessity, they lost 2-3 months of pay. They could not pay their obligations. Their landlords came to evict them. Those are some of the cases where it's very clear that what happened was completely outside of that tenant's control. Most people don't have 3 months worth of all of their expenses sitting in the bank. And so in cases like that, that's where we're seeing the seal granted.
Is that at the discretion of the district court judge?
It is 100% up to the discretion of the district court judge.
So all it takes is for a request to be made of the judge to seal this proceeding. Can that be done by somebody on their own if they don't have an attorney involved?
It can be done pro se. What we are without an attorney, most folks that we're finding where we're successful are where there is an attorney involved. There is a brief that I think every legal services attorney in the state uses that I wrote, but it literally references the Bentley case. There are a few other examples of kind of high profile civil cases that get sealed. It boggles my mind that it's not uncommon that maybe a settlement agreement in a corporate dispute can be sealed, but this kind of case can't. Why we somehow think there's more of a public interest in knowing that somebody that didn't pay their rent. And it's been really nice to see the mentality shift around that, even if it did come out of crappy circumstances.
Well, but I want to underscore what I just heard you say. That's being done by legal services offices across Alabama, and it's based upon a brief that Holly Ray wrote. Is that correct?
Yes.
Awesome work. That's great. I've learned something, and that's will offer tremendous assistance to people facing eviction. Another topic you mentioned, and we talked about a little bit when you last appeared, and those are the rental assistance programs. I think you told me when we last spoke that a lot of that money had not yet been spent. Can you bring us up to date on these rental assistance programs and how people can take advantage of them?
Sure. So in Alabama, the primary program is ERA Alabama, and you can visit their website. It's eraalabama.com.
We'll make sure that's on our Facebook pages for our viewers.
A handful of cities and counties were also able to get their own piece of that federal pot of money. Here in Huntsville and Madison County each have their own programs. Mobile County has its own. The city of Birmingham has its own. The Tuscaloosa County has its own. And they will all link off of eraalabama.com rather than be spitting out 13 websites at you. But the point of each of those programs is that they can pay rent going back as far as March of 2020. In some cases, they can, depending on how many months total of assistance you need, they can even give you 3 months of forward assistance. So, we're sitting in September, they could conceivably pay October, November, December if you still have a COVID-related hardship, which, it's hard to believe, but we're still seeing that kids in virtual school around the state, things like that, that certainly affect people's ability to work and ability to earn. I know that the city of Huntsville has given away over half of its money. I believe the state has crossed, I want to say the 25% mark, but that may be higher. I haven't pulled their statistics in the past few weeks. One unique statistic that I did get this week is that the state started working with legal services on an imminent eviction prevention project. And what that means is folks who come into us with eviction papers, their landlord has given them a notice or they've been served by the court, but they are eligible for rental assistance. They will allow legal aid lawyers to ask that those applications be expedited. Basically, kick those to the front of the list, because if they sit on that list for a month, the tenant's not going to be living there by the time you look at it. They have done very well on that with us, and they've given away over $1 million. We crossed $1 million last week to legal aid clients who are in need of eviction assistance. And those are cases in court. So that is $1 million that stopped evictions that would otherwise have proceeded within 2 weeks of application.
That's fantastic, because I remember you told me last time that one of the problems with this rental assistance program is that the paperwork and the process was kind of convoluted and it was slowing things down, but it sounds like they've freed that up by letting your attorneys be directly involved with that process.
Absolutely. A lot of folks don't have a scanner at home to scan in their documents or a printer to print and then scan a signed document. We have all of that sitting in our office right behind us. I'm happy to help people fill out for this money. What I tell folks is it's really a stimulus for landlords. Yes, it pays your rent, but what it really does is pay your landlord. It is actually a business stimulus if you sit down and think about it for a second. Yeah. And, at the end of the day, I want that money to stay in Alabama. I don't want that money kicked back to Washington, because I want Alabama to keep affordable housing, and this is how we do it.
And what Holly just said there, I want to underscore so many of the things you've said. I've wanted to repeat, but landlords, Holly and I both represent consumers. We usually are representing the person that can't pay their rent, can't pay their bills. But these rental assistance programs are open to you as landlords also. We want to get that money to you on behalf of the people we represent. So, Holly, I think I understand this correctly. Landlords can also apply for this money on behalf of tenants. Is that correct?
Yes. Both parties have to apply and be willing to accept the money. So landlords can apply to get paid themselves, and as long as the tenant verifies their hardship, that is enough to get it paid. And the money gets cut directly to the landlord. The tenant never sees this money. So that's kind of an important point is, you see some of the public perception around this, and you represent consumers. You get all of this. We are not paying for deadbeats kind of stuff. It is literally a subsidy to keep affordable housing in the state is what it is. And the check goes directly to the landlord. The tenant never sees that cash.
And I just hate that term, and I know you do too, Holly. The people we represent, the vast majority of people we represent are not deadbeats. They're good, hardworking people. Folks, it can happen to anybody, and it's happened to folks that never would have gotten into this type of situation before last year. Good, honest, hardworking people have financial problems. Holly, I'm gonna just talk a little bit about bond and BOTUS here for a second, then we're gonna come back and we're gonna talk about some questions that we've had come in through various sources from our viewers that I want to give you a chance to answer. But folks, the bond and BOTUS law offices are located throughout Alabama and Mississippi. For 35 years now, I have helped people with financial problems. And the landscape has changed significantly over this last year and a half. People that never would have dreamed of being behind on their bills, are unable to pay their rent, are unable to pay their mortgage, are finding themselves in that situation. It is very important, if you're in this type of situation, that you be proactive right now. Don't wait until that eviction notice comes. Don't wait until that foreclosure notice or wage garnishment or an automobile repossession occurs. If you think you're going to be behind on your bills, reach out for help now. Our offices are offering absolutely free initial consultations. We'll do them from the safety, the comfort of your own home or office. We'll do them by video, like I'm meeting with Holly Ray today. We'll do them by telephone, however you're comfortable with. The initial consultation is absolutely free. We want to help you, so please reach out for help. We are talking about the end of the eviction moratorium by order of the United States Supreme Court today, and we're talking specifically about how the process works in the state of Alabama. Next week, next Wednesday at this same time, we're going to do an episode focusing on the eviction process in Mississippi. My partner, Ed Woods, who manages the bond and BOTUS law offices in Mississippi and who's also a justice court judge in Mississippi, will appear to talk about that process and what rights consumers have in Mississippi. If you know somebody either in Alabama or in Mississippi that may be behind on their rent, that may be facing a potential eviction, and you think they'd benefit from today's episode, please share this with them. These videos live on our Facebook page, and they're also available on our website. So please share this information. The information being provided by Holly Ray with Alabama Legal Services today. I'm even learning from it. I was not aware of some of the type relief that is available that Holly Ray's already discussed with us today. We are going to now, if good with you, Holly Ray, take some of the questions that have come in from our viewers. I never know exactly what we're going to get here. But the first question is here. How long will I have until I get evicted? You've already talked about this a little bit, but why don't you give another synopsis of if somebody is unable to pay their rent, they're behind. I think a lot of folks, they get a notice from their landlord and they feel like they have to move out immediately. That's not necessarily the case. Talk to us about how long somebody has after receiving an eviction notice.
Sure. So if you've received the notice from your landlord, but not an unlawful detainer from the court yet, at bare minimum, presuming you file an answer in the eviction, you have a month to move. Where I'm pulling that number from is that from the day you get that notice, you have 7 business days to cure or quit. If you do neither of those things, they file the unlawful detainer. You have 7 calendar days to answer that unlawful detainer. By definition, once you filed your answer, the case has to be set at least 14 days out, and generally it's going to be a little bit longer. I tell folks to expect 2 to 3 weeks. Even if you lose at court, you've got 7 days to be out. So when you tie all those things together, from that first late notice, you've got at least a month before you'd be out. There are moving parts in there with regard to how long it takes to set the case for a docket. If it gets to that point, how long it takes the sheriff to serve the writ of possession. That can move faster or slower depending on the time of year and how many cases are in the docket. But in general, you've got at least a month.
Yeah, two things I want to reiterate here. Hallie, I'm sure you see this also, but a lot of folks don't understand the difference between a letter they receive from an attorney and a document they receive from the court. So that first notice is going to come from your landlord or often your landlord's attorney. That's not a court document. It's an important document because it says you're in default and you need to do something to get out of default. And then if you don't do that, you're going to get the court document. When you get that court document, I can't say it enough. You can't just sit back. You have to be proactive. In order to get this additional month that Hallie Ray talked about, you've got to file a response to that lawsuit, and you only have 7 days to do it. So don't just sit back. Don't wait until the day before. Don't wait until the sheriff's at your house. As soon as you get that unlawful detainer, which is a type of lawsuit asking that you be evicted from the property because you're in default on your rent, you need to act. You need to file a response. And Hallie, I think you said the form, a document you need to answer that complaint. It's nothing sophisticated. It's something available in just about, I think, in all clerk of court's office, correct?
There is a fill in the blank answer form that is generic. It came out of the administrative office of courts. Every clerk's office will have it. It's going to have some check boxes on it for things like, I don't owe anything. I admit that I owe some, but not all, blah, blah, blah. I tell people to check the box for other and just write, I want my day in court. A common misconception is that you need to write your whole life story and your why for the judge. Chances are they won't read it. Chances are that if they do, you might put something incriminating in there. Don't do it. Just check the box for other and say, I want my day in court. That is enough.
Don't ever check the box that says, I admit everything said in the complaint.
Yeah. If you check, I admit everything, you don't get a day in court because there's nothing to fight over.
And Hallie, this is just an interesting aside, but it's always been something that's upset me, and I'm sure you see it. I don't know if it exists in the form answer for an unlawful detainer, but for most other collection suits, it has a place for the defendant to list their employer there.
Yeah.
Their employer's name and address. Don't provide that information, folks. You don't need to provide it, and all you're doing is telling that plaintiff where they can garnish your wages if you lose that lawsuit.
You're making their job easier. Don't do that. Make it work for them. Make them work for it.
All right. All you need is a response saying you want your day in court. Don't give them any other information at that point.
I will say the clerk will ask for your phone number on that form. I do recommend giving a valid phone number. And the reason is we live in Alabama. We're coming into the fall tornado season, one of two. It is not uncommon that weather outages may close the courthouse, or in some cases, COVID-related stuff will close a courtroom. They will have no way to reach you without a phone number for you. A letter is not going to reach you the day of court when the tornado warning gets issued. The clerk's office or the judge's assistant will call you. So I do recommend putting your phone number. Please don't give them your employer. They don't need it.
Another important thing here, and I guess I'm expanding this a little bit, Hallie Ray, because we often see this with collection type lawsuits. Make sure the court has a good mailing address for you too, because what the court's going to do when you file that response is send you a notice letting you know when the court hearing is going to be. And if they don't have a good mailing address for you, you're not going to receive that notice. Next question, Hallie Ray. Is there a chance the government will make my landlord forgive the missed payments?
I don't see how in the world they could constitutionally.
Yeah. And that's why we are where we are now. And I gave a brief synopsis, and I don't know that we need to go into a lot of detail here, but essentially the United States Supreme Court with its current makeup, hi Ruth behind you, with our current Supreme Court's makeup has said that the CDC did not have authority to put a prohibition or a moratorium on evictions. And that's why the eviction process is going forward. So as Hallie just said to this viewer, I think it's probably unlikely that the government's going to be able to step in and forgive these type rent payments But we should reiterate, Holly, what you said earlier. There is money available for renters assistance. The state of Alabama, and I know the state of Mississippi also, does have money available to help both the landlord and the tenant if you're behind on your rent due to COVID. All right, next question here. Well, I guess this is a landlord asking a question here, and we need to go ahead and address this. What options do landlords have for evicting unpaid tenants? But the most important option, Holly Ray, I'd like you to talk about there is applying to the state of Alabama for rental assistance.
Absolutely. At the end of the day, chances are good if you evict this tenant. Far be it from me to quote the recovery statistics, but something like less than 15% of landlords ever completely recover their judgment for unpaid debt. You don't want to spend 20 years chasing this person down when you could wait 2 weeks and get money out of the state of Alabama. You're going to pay much more to a collection lawyer than you would the cost of 2 weeks of waiting for money. So for landlords who are needing to evict a tenant who hasn't paid, option one, in my opinion, should be going for rental assistance. If that doesn't work with the moratorium currently out of place, what the Supreme Court basically said is that the CDC didn't have the constitutional right to do what it did, that had to come out of Congress. That may yet come out of Congress. There are murmurs, but it hasn't yet. We would be back to business as normal in terms of evictions. I would say that if this landlord is not a sole proprietor, if they operate their rental business as an LLC or a corporation, remember that an LLC or a corporation cannot represent itself in district court. So if you own it through any kind of incorporation, you do have to have counsel. And I would always encourage a landlord to seek legal counsel, if only because, pro se landlords really get mad when you win your case off of stupid lawyer tricks because they didn't put the right cure in, or they gave them 7 calendar days instead of 7 business. Get good counsel on these. It's going to save you more money than filing twice, losing to me, and cussing me out in the parking lot.
I'm gonna rephrase what Holly Ray said. There's stupid lawyer tricks. That's good lawyering, folks. If you have a good attorney representing you, either through legal services or if you're able to hire a private attorney, there are hoops that a landlord needs to jump through and do it properly in order to evict you from your residence. And a good attorney is going to make sure they jump through all of those hoops. Big difference as to whether or not the landlord is an individual as opposed to an LLC or a corporation. That they properly gave you that notice of your right to cure the default, that they complied with that, whatever provisions may be in the lease. We may call them stupid lawyer tricks, but if you're somebody that wants to stay in your home and you need good legal assistance, it's going to be good lawyering, and you need a good lawyer. And you can find them if you qualify at Alabama Legal Services. And if not, we'll certainly be glad to help you at the Bond and Bodas law offices. I do want to say one more time, if you think bankruptcy protection is the appropriate step, you certainly should consult with one of us just as soon as possible, because it's important that your petition seeking bankruptcy protection be filed before an eviction judgment is entered against you. And that, as Holly Ray has told us, happens very quickly in the state of Alabama. And landlords, again, the odds of you collecting that back rent from somebody that you've evicted are very, very low. Go to the state of Alabama, see if you can work with your tenant to collect that back rent and help that person stay on their feet and keep a good paying tenant post-COVID in your apartment or in the home that you're renting to them. I have another question here, and I think you've addressed this earlier, but this person is renting from a landlord. Apparently, the landlord is facing a foreclosure proceeding. So if my apartment goes into foreclosure, will my landlord still be able to evict me?
So that's a loaded question. Foreclosure in and of itself does not mean that you don't owe the debt. In many cases, we have a right of redemption in Alabama. Your landlord could redeem the property. That in and of itself would still keep you owing the rent. The property may get bought at foreclosure auction to a new buyer. That can get really confusing when you start getting notices from multiple people saying you owe me my rent and you don't know who you owe. Please call us if that happens. We saw a lot of that back at, during the Great Recession, the 2008, 2010-ish era. But in general, if something happens, your property is sold and you have no idea who to pay rent to, and man, has this happened. We've had homeowners who were renting a home who were foreclosed on and the bank never got in touch with the tenant. When that happens, my best advice, do not spend that rent money. Put it in a savings account, hold it in escrow, as it were, so that when this gets ironed out, you aren't facing eviction for non-payment of rent and you don't have the ability to bring it current. Put that money aside to show in good faith that, hey, there was a legitimate dispute as to whether I owed ABC Corp or John Doe. Neither one of them could prove to me that which one I was supposed to pay, and they were both saying I owed them, both sending me late notices. Here's the money, Your Honor. Tell me who I owe it to. It is a much easier case to try than, well, where'd the money go? I don't know.
But this situation to this viewer may lead to one of those smart lawyer tricks, I'm going to say. Yeah. Smart lawyer, stupid lawyer trick. The landlord, when he gets to court, needs to be able, or whoever it is that's trying to evict you, needs to be able to prove that they have standing, that they have a right to evict you. And if the property's been foreclosed from under them, then your previous landlord may no longer have that right. Again, this is something that a good attorney at Legal Services or a private attorney, if you don't qualify, is going to be able to help you with. It's very important that the person suing you have standing to do so and be able to prove that to the courts. I have an important question on behalf of our viewers, Holly Ray, and that is, if I am a consumer or an individual in Alabama and I qualify for the assistance of Alabama Legal Services, how do I get in touch with you?
Sure. So the two easiest ways to apply for legal aid, we have a website, legalservicesalabama.org. You can apply online straight off of the website. You can also apply through our hotline, which is 866-456-4995. We have people who answer in both English and Spanish on the hotline. Because of COVID, I know that people love to walk in the front door of our offices. We do have to limit the number of folks in our lobby. And so I hate for people to spend the gas money to come up to the front door and then they find out we're all in court or the lobby is full of people and they're going to have to wait in their car. So I do ask that folks apply through one of those two means first. Our hotline is very, very good. Our website folks are very, very good at checking applications, and getting them over to us within 20 minutes of somebody applying. Even with time-sensitive emergencies, you'd be shocked how many times they just send me a text and say, I'm sending John Doe your way. John Doe's answer is due today and it's 3:00. Right. Both of those are going to be smart, fast ways to get in touch with us.
Well, and we have that information on the screen for our viewers, and we'll make sure it's available on our Facebook pages also. The folks at Alabama Legal Services do excellent work. If you qualify their assistance, please call the phone number, go to their website. Even though Holly Ray just gave the example of getting a text at 3:00 with a response needing to be filed that day, please don't wait to the last minute. Please try to give us, whether it's the folks at Alabama Legal Services or our attorneys at the Bond and Bogus Law offices, try to get to us just as soon as possible. As far out in front of the problem as you can, the better we're going to be able to do to help you. Holly, I do want to just comment. I know you talked about this with my partner, Ron Sixtus, when you appeared on the podcast, but how we interact with clients, how we interact with everyone has really just changed so significantly over the last year and a half. A year and a half ago, I would have told you that I really didn't want to meet with a client virtually. I wanted to sit down and shake their hand and look them in the eye. But a lot of our clients, and I'm sure the same is true for you, it's just, having to take off work, drive to our office, sit in our lobby, wait to see an attorney. Right now, we can just buzz in and do a video consultation with you or a phone consultation, and we can do them pretty darn effectively. Yeah. You finding the same thing in your offices?
Absolutely. Pre-COVID, there was a strong preference for coming in, meeting with people face to face, having them sign physical documents. The reality of legal aid is we cover the entire state with 7 offices. Some of our clients live an hour and a half from our office. Being able to have people sign virtually, being able to do virtual consults, really, we very quickly realized what an access to justice issue it was.
Yeah.
That if I told someone from Coleman that they had to drive here to see me, I might as well have been telling them to go book a plane trip to Paris.
Right.
And so I've really kind of learned the ins and outs of doing Zoom meetings with people with various levels of tech savvy. It's really been an interesting learning process.
Well, the folks at Alabama Legal Services, the folks at Bond and Modus Law Offices, we're available. We'll meet with you however you feel comfortable doing so, but be proactive, reach out for help. Holly Ray, I want to be respectful of your time. We're nearing the end of the hour. Let me just close by saying again to our viewers out there, we know a lot of you are having financial challenges right now. We know how stressful it can be for you and your family, for you and your marriage when you can't pay your bills. There are options available. Please reach out for assistance. If you qualify for Alabama Legal Services and it's an area of the law that they can help you in, certainly reach out to Holly Ray and her folks through the contact information on your screen. If we can help you at the Bond and Modus Law Offices, we're offering absolutely free initial consultations with an experienced attorney. So please either go to our website or call the phone number on your screen, and we'll be glad to help you. Look forward to next week. If you're in Mississippi, or if you know someone in Mississippi that may be facing an eviction or somebody that's behind on their rent, we'll feature Ed Woods, who is the Bond and Modus managing attorney for our Mississippi offices. He's also a justice court judge, so he can talk specifically to eviction issues and other justice court type issues that impact consumers. Holly Ray, thank you so much for joining us. On behalf of everybody at Alabama Legal Services and all of us at Bond and Modus, thanks for joining us. We'll look forward to seeing you again next week, and have a great rest of the week. Thank you, ma'am.
Thank you so much.